as well as witness statements that were on file and the post-mortem reports. You have it.
It's deliberately not on. I don't need it.
But since we are in the sentencing hearing, that just for completeness, so that it sits together as a whole, we thought it was necessary for those to be gone through. I know they have been said before, but I'm not explaining in relation to some may have heard it said before.
Very well, my lord. On the morning of the 21st day of June 2022, at approximately 7:46 a.m., Mr. Renardo Powell visited the home of his sister, Miss Kimisha Wright, after he unsuccessfully placed several calls to her cellular. Smith, 15 years old, Miss Shara Lee Smith, 11 years old, and Miss Rafaela Smith, 5 years old. Based on this discovery, the police were contacted. On their arrival, they commenced investigations into a case of murder. In processing the scene of the crime, the area surrounding the dwelling house was searched. A pair of brown shorts, which appeared to have dried blood stains, as well as a knife with what appeared to be blood stains, were seen in nearby bushes. A witness who had been in the company of the accused, Rushane Barnett, on Monday, the 21st day of June 2022, was taken to the vicinity of where these items were discovered, and he identified the knife as belonging to the accused, as well as the shorts as being the he was wearing on the evening before the bodies were discovered. The witness stated that on the night preceding the discovery of the bodies, he was in the company of the accused, Mr. Rushane Barnett, who was the maternal cousin of the deceased, and that Mr. Rushane Barnett was in possession of the same knife that had been discovered with the bloodstains, that he had uttered the following words, that is Mr. Barnett, and I quote, "Me go warn me brother out of Chapelton, say me I go kill some people tonight, so him feel look out of him eye." End of quote. Based on the evidentiary material discovered on the scene and the information gathered, Mr. Rushane Barnett, otherwise called Jet, was apprehended on Tuesday, the 21st day of June, 2022 in Wilson Run in Warsaw, Trelawney Police District. On the 22nd day of June 2022, Mr. Rushane Barnett gave a caution statement to the police in the presence of two justices of the peace.
I'm sorry, madam, I think that was indicated before. That may be incorrect. It might have been in the courtesy of counsel.
I'm so very sorry. Thank you, madam. It was corrected. My learned colleague is telling me. I would ask that the facts be officially amended on the record. On the 22nd day of June 2022, he gave a caution statement to the police in the presence of his attorney. In that statement, He gave an account of how he murdered Miss Kamisha Wright and her 4 children. He also, and I would here add this to the record, gave a question and answer statement under caution in the presence of his attorney on the 22nd of June 2022, where he gave more details in respect of the incident surrounding the murder. He stated as follows, and this is in summary. 1, at one night, he was at the home, which is occupied by the deceased and her children in Cocopies. He refers to the deceased as Chinny and the children as Chin, Plummy, and the baby as Kishane Henry. He stated that 2 men came and ordered some items, and he served them. The deceased, who was present, grabbed the money he collected from the men and told him not to serve any of her customers. She did this in front of the customers, and he felt disrespected. After doing this, she flashed some water in his face. Since this incident, the deceased's disposition towards him had changed. The children also started distancing themselves from him after this incident. During the night of Monday, the 20th day of June 2022, at approximately 12 midnight to 1 a.m., he was at the deceased's home, and the deceased told him to lock up the place. He told her that it sounded as if a vehicle was at the gate. She took a look and said she did not see anything. He looked at her, and she looked at him as if she saw that he was preying her. She made after something on the dresser, but he did not see what it was. He prayed in the heavens that it was a knife or a scissors. He had his knife on him, and he stabbed her up, and she dropped the children. 2 of the children, Chin and Plummy, rushed on the dresser and took up 2 things in their hands and started throwing at him. He did not see what it was. He grabbed after them and started stabbing them up as well. The big child drew for a scissors. When he saw this, he rushed into her room, and she fell, and he started stabbing her up. When everybody was dead, he charged off and threw the shorts and knife over the side where the ackee tree was located. A post-mortem examination was conducted on the bodies of all 5 deceased persons. The injuries observed and the cause of death are recorded by the pathologist as follows. 1, Miss Kamisha Wright. 48 incised wounds, all in the region of the neck, chest, abdomen, and limbs. Cause of death was due to hemorrhage and shock and multiple sharp force injuries. 2, Kishane Henry. 11 incised wounds, inclusive of an incised wound to the neck, which has been described as a cutthroat injury. 3, Kimanda Smith. 9 incised wounds and 4 stab wounds. Cause of death was hemorrhage and shock and multiple stab wounds. 4, Shara Lee Smith, 22 incised wounds and 2 scratches. Cause of death was due to hemorrhage and shock and incised wound to the neck, cutthroat injury. 5, Rafaela Smith, 5 incised wounds and a gaping wound to the upper anterior neck. Cause of death was due to hemorrhage and shock and incised wound to the neck, which had been described as a cutthroat injury. And of course, the accused, Rushane Barnett, was subsequently arrested and charged for 5 counts of murder in this matter. I would now seek your lordship's leave in order to complete the presentation of the main documents on which, or the evidentiary material on which the Crown has based its case. I would seek your lordship's leave for the caution statement that was recorded from Mr. Rushane Barnett in the presence of his attorney to be read by your leave into the record by the registrar.
Mr. Registrar, can you read the caution statement in?
Caution statement, name, Rushane Barnett, date of birth, the 18th of the 10th, 1998, age 23. Place of interview, Major Investigation Division, MID. Name of statement taker, Philip Dodd, Detective Inspector. Date, 22nd of the 6th, 22. Time commenced, 5:30 p.m. Time completed, 7:32 p.m. Persons present, Nicholas Kellyman, Attorney at Law, Detective Inspector P. Dodd, Detective Woman Corporal Cherie Thomas. Offense, murder. You are not obliged to say anything unless you wish to do so, but anything you say may be taken down in writing and may be given in evidence. Signature or mark R. Barnett, date 22nd of the 6th, 2022. I, Rushane Barnett, wish to make a statement. I want someone to write down what I say. I have been told that I need not say anything unless I wish to do so, and that whatever I say may be given in evidence. Signature or mark R. Barnett, date 22nd of the 6th, 2022. States, so, me inna the crib one night, everybody a go away, ya know. Chinese say, me fi lock up the place. Same time, me lock up the place. 2 nigger forward on the block. Same time. One of them call and order something from me. While me bringing the stuff them out to the nigger, Chinese opened the door. Said time. She a say, yo, anytime anybody forward fi buy nothing, call me, make me sell, cause you know have nothing in my place. You know have nothing in my place. So she grabbed the money from me and go for the things them and give the youth. The youth go away and leave one of the youth outside. Then me go in at the crib. Now, same time, she forward in her, which part me there. Meanwhile, me I take out me things, them. She go in the fridge. Throw out some water in a cup. She say, she see me, all me things them, all move out. I move out. She start give me body eye. So me look back pan away, and she flash some water in my face. We never retaliate. All me things them all move out. I move out. She start give me body eye. Flash some water in my face. I never retaliate. Okay, I'll continue. Me never retaliate. Same time, me step out and tell the nigger outside, say me bounce, me go out of my crib now and start pretty deep in my heavens. And I wonder if I really diss my family or diss me. Me never retaliate. Same time, step out and tell the nigger outside, say me bounce, me go out of my crib now and start pretty deep in my heaven. And I wonder if I really diss my family or diss me. I couldn't turn it off from here. Where was I? No. And me start deep in my heavens, and I wonder if I really diss my family or diss me. And me dead right through with the baby alone. Any nigga forward upon the block, me sell them and not there with the big girl alone. Sell right through. All right, my lord. With the baby alone. Any nigga forward upon the block, me sell them.
All right, now what we're trying to do is ensure that we can turn this off. As I say that for reasons of transparency, because of the public profile of this matter, just thought helpful with the live stream so that other persons could hear with an hour of another time. That, however, cannot be something that delays and interferes with the processes of court. So we're trying to see how we can improve and or remove these kinds of these parties that we use.
Yes, my lord. Yes, my lord.
So, just to be clear to them, that we're going to continue. If they that happens again, I want to talk. Yes, we can't do these things because of their. You can add those. Yes, all right.
Where me start from now? My lord? Yes, my lord. All right. Any nigga forward upon the block, me sell them, and me daddy with the big girl alone, sell right through, said way, so me have to really a meds. How she a tell me fi no sell nothing in her place and flash water in her me face. In the morning, now me see the same nigga where did there pon the block, and I suggest the thing to him. All that's him look pon me, and I say, Mama this you for real a joke thing that, and him even turn to her and say, you shouldn't style the youth like that. So me start pre in a me heaven. So now, fi I really she diss me. And I watch her and I say, when she and me meet up, if she a go make it up back or say something to me. But she not say that. She see me and cut her eye off of me. Me see the kids them now talk to me, so me start pre or upon a level, you know. I could have what me do her, make she not talk to me, and as she diss me, and is not like the first me I sell in the crib. So me get fi find out say she and the youth were come by the thing them have our beef together. Like when me bounce on the street, a pure talking from nigger, oh me watch my family yard and I sleep in a settee. Say me a pre-R me a pre-R grime upon a level. You know, me leave me crib just for company you in a your crib, and she want style me, and I give nigga things for talk. In the street, me feel beat. Sorry, me feel upset about that, cause everywhere me go, me hear nigga whisper and laugh to them one another about the same thing. Me a pray how me saw. My lord, oh, sorry, my lord. I'm on the third. No, not Grimley. I'm past here. Page 3, my lord. I'm about 7 line from the bottom. No. It's the first word in the 1, 2, 3, 4, 5, 6. What is it? Militant. Oh, militant. Yeah. Militant. Oh, yeah. Yes, madam. Me a pre how me so militant to her, and she take me as some yard boy and some fool under style. So me just keep me distant, and she keep her distant. She keep fear distant. The kids them that are even the kids them that are how everything get from farm up. So me I go tell you what happened. No. Me check in the morning, and a nigga upon a decking top side the house. She did there, and she did there at work, said we, and even our brother, so me rotate the bucket, figure up at the decking top. The nigga them find fault, like them want tell me how they work and how me I go mash up myself, and one bagger program thing. Every nigga upon the site at the bars. So according to the whole heap talking upon the site, me just tell the boss, say, me stop work and him not have to pay me. Me just tell him give me a juice money for what me do. And him say me no do nothing from morning. So me piss off and step off the site. I go out of my crib, go all bed and circle back up at the site When me reach back up at the site, Chinny brother catch up a fight with a nigger named Cheng. So me have to part the thing. Chinny have to part the thing too. Chinny. It happened that Chinny said me fi bring him brother out of him yard and take a wash off, and we say we are circle the bar. A next nigga from next door say him I make a bounce with we too. So we go out there, drink 2 guineas, said time, me tell them say, me a roll, a bounce go out a Reds. It happened that me out there pan the block, the baby and the big girl did a, the baby and the big girl did in the crib same time. She forward upon the block to inna the 8 I go to 9. So time. Oh, so same time she has said me can stay upon the block tonight. If me no want to leave, me do stay upon the block. She forward round at the living room and said she a go lock up. So, she a go lock up here now, so me can lock the front door. So me inna the crib a go on build back after me lock up the place, same time me hear like a vehicle stop down at the gate. So me go round a FR side now, tell her if you take a look through the window down at the road. She take a look and say she no see nothing. Same time, me say it look like the vehicle gone. By time she fi look, she a walk come out of the bed now, to the bed now, and it seem like she see me a prayer. So she make offer something pon the dresser. Me no see a what, but me a pray in, and me even say it's either a knife or scissors. Me rush her now cause me did have a knife. Then me start stab her up. She drop the picnic, them get up here now, Chin and Plummy, rush pon the dresser, take up 2 things in them and start fling it after me. Me never really see our that good, so me start grab half of them, and start stab them up too. The big one draw scissors. When me see that now, she rush in her room and she drop and me start stab her. Brother, so me rotate the bucket. I left from 4 to 5 minutes. Same time.
That is 5. That is page 5.
Oh, sorry. Yes, my lord. Sorry. Yes, my lord. Stab her up, so everybody dead now. So me change off, throw throw the shards and knife over the right side where the ackee tree there, over the bush, and bounce, so that are all thing now. That other thing now, me decide say me I go Trelawney, go turn in myself up a Warsaw station, cause me hear say the thing loud all over the street. When me reach a yard now, my brother and father and mother I say them a get a call from my bigger brother where work at Strawberry Hotel up Irish Town. Say him here say Chinny and the 4 picnic them dead. But them no know who do the crime. They only have me as a suspect. True, me used to stay at the crib. Me never make them know, say I me kill them. My brother get called from 2 warden friend where we and them grow up together and say them hear Rushane Barnett name a call up, say him are the suspect for the 5 murder. Me take the phone from him and talk to one of the warden them. When him call and tell him say, me I go turn in myself, me tell him me I go take a taxi, go up at the station. Him say, cool, me fi stay in the crib, him I go send the police them right away. At the yard, me no fi do nothing. Me no fi do nothing funny and let him down, cause him depend on me. So me stay in the crib till the police them come. Police them forward, cause me tell him say me nah run, so them forward introduce themselves and we bounce. Yeah man, at that. Sign B.R. Barnett, date 22nd of the 6th, 2022. Witness, signature, and date 22nd of the 6th, 2022. Read the declaration. The foregoing statement was read over to me. I was told that I could add, alter, or correct anything I wish. This statement is true. I make it of my own free will. Signature of interviewee R. Barnett. Signature of witness. Date 22nd of the 6th, 2022. Recorded by me, Detective Inspector Philip Dodd, on the 22nd day of June, 2022, at the Office of the Major Investigation Division, in the presence of Mr. Nicholas Kellyman, attorney at law. The statement was read over to the maker, who was informed he could add, alter, or correct anything he wishes to made known.
Sorry,
He made none.
he made none.
It was signed by him as true and correct. Signature, P. Dodd, Detective Inspector, date 22nd of the 6th, 2022.
Ms. Llewellyn, we also have a question and answer.
Question and answer on the portion is so 79 questions and answers that were given Barnett to the police in the presence of his attorney under caution.
And you'd have no difficulty for the question and answer to be deemed part of the record for the purposes of sentencing without the necessity of having it read?
Well, I would have no difficulty. I don't know if my learned
I will,
friend
yes.
for the defense would have any difficulty.
Ms. Harris? Very well. So therefore, the question and answer of Mr. Barnett, 79 questions as the Crown has indicated, which is dated the same date, the 22nd of June 2022, is deemed part of the record for the purposes of sentencing. Thank you very much. Yes, madam.
We also have the social inquiry report.
Yes. Very well. There's a social inquiry report into the circumstances. The probation officer, and I need to publicly say that I thank them for what has been a very comprehensive report. For purposes of the confidentiality of the report, the probation officer is present, and what the probation officers do is they speak to members of the family of the victims, members of the family of the accused, and community members. Some of the information that they have gained is confidential, but it is something which assists the court. The Crown would have seen it, and the defense would have seen it also, but I am going to ask if that too can be deemed part of the record. Report being read into court. Ms. Llewellyn, what's your position in relation to that?
I have no objection to that, my lord. Although, if your lordship had been minded to, well, it would have been nice to ask them, or just for them to confirm that they did speak to interview the accused at length, and that they interviewed relatives of all the deceased at length.
Yes. Yes,
so that is quite clear and transparent.
Yeah, there are comprehensive statements here on the document from relatives of the deceased and relatives of the accused also. And as I've said.
And the accused himself.
And the accused himself. Thank you very much, madam.
Just for the record.
And community members in various communities.
That is
in relation to that. So,
I have no objection.
Very well. Ms. Harris, you have no objection to the social inquiry report being deemed part of the record for the purposes of sentencing? No. Very well. The social inquiry report for Mr. Rushane Barnett, which is dated the 19th of September 2022, and prepared by the probation office.
Could we have the names for the record, my lord?
No.
Oh, I'm sorry. The
names of the persons who have done the report? No.
Oh, your lordship would not wish to have that? Very well.
I'm deliberately not doing that. Prepared by the Department of Correctional Services Probation Aftercare Officers, is deemed part of the record for the purposes of sentencing. The documents are before the court with the relevant persons. As I've indicated, Ms. Llewellyn, for your purpose and for other purposes, the probation officers perform a very helpful role by speaking to both the victims of crimes and persons related to accused persons and community members. They give very helpful information for the court, and they sometimes they get that information with a level of confidentiality.
That is so,
and so that's why we're not reading it into court. And I'm not naming the probation officers because...
And that perhaps is prudent.
Yes. They will not hold it against me that their names are not in this situation. They'll be very happy, in fact.
But if your lordship may permit me to also, on behalf of my team and my office, to commend both probation officers for the very, very, very great detail that they went into in gathering the information from not only the accused, relatives of the accused, relatives of the victims, and community members in areas connected to the accused and the victims, which made a very comprehensive report. And I would wish to record my commendation
Very well, ma'am.
for the high quality.
Yes. We acknowledge that. As a report where I think that at least 3 parishes had to cooperate in getting the information here. Very well. We also have an antecedent report before the court. And
Might the probation officers be given leave of the court?
certainly, if they wish to go, they have leave to do so.
Thank you, my lord. In respect of the antecedent report, my lord,
Yes.
which was collected by the court detective,
Yes.
your lordship would be minded to hear that in the usual manner?
Yes, madam.
Very well, my lord. Mr. Registrar?
I swear by Almighty God that I shall true answers make to all such questions as this honorable court shall demand of me.
Well,
Mr. Registrar, could we have a copy of the antecedent report
oh,
in the usual manner?
I'm very sorry. I see that
Thank you.
both the Crown and the defense that may have been missing. Could you just test that microphone again for me, please, sir? You're very, no, by speaking into it. Doing that just only damages.
Adrian. Okay.
You hear me? Very well.
Adrian Robinson,
Yes.
Detective Constable, attached to the Home Circuit Court. Antecedent report of Rushane Barnett, otherwise called G Unit. Barnett, otherwise called G Unit, 23 years old, laborer of 47 Tavern Drive, Kingston 6. Indicted in the Home Circuit Court for the offense of murder, 5 counts. Mr. Barnett was born on the 18th of October 1998 at Wilson Run in Trelawney. Mr. Barnett grew up with his mother, Janet Barnett, father, Shane Barnett. He is the 6th of 7 children for his mother and the 5th of 8 children for his father. He began his early childhood education at Trelawney Basic School, then on to Wilson's Run Primary School, where he spent 6 years. He did the GSAT and was awarded a place at Troy High School, where he spent several years. He did not complete his tenure. He is literate. After leaving school, he moved to Kingston and started learning boxing at Stanley Couch Gym, located at East Queen Street, Kingston, CSO. Simultaneously, he worked as a laborer on construction sites, earning about $12,500 weekly. He worked briefly at Tropical Supermarket, earning $14,000 fortnightly. He was doing boxing and construction work at the time of his arrest for the above offense. He is single and has no dependent. He believes in the Christian faith and formerly attended Seventh-day Adventist Church, but now prefers to worship and attend church on a Sunday. He has no previous conviction recorded against his name. The foregoing information contained in this report was garnered from the accused and the Criminal Records Office.
I have no questions, Willard, with your leave, I wonder if your lordship would be minded, for the record, to the expert report of Dr. Clayton Sewell, for the record to be read into the record. Well, taken as read. Taken as read.
I had wondered whether or not it was going to be on the Crown's case or on the defense's case.
I think in the interest of justice, it would be both. It doesn't make any difference because it would assist the court and it would, if it goes elsewhere, assist the record.
Do you have any objection for the medical report to be being part of the record for the purposes of sentencing? In other words, if that is ready?
No, my lord.
Very well.
Thank you.
Very well. Therefore, in those circumstances, the expert report of Dr. Clayton Sewell, which is dated the 27th of July, 2022, a report consisting of 12 pages, is being part of the record for the purposes of sentencing.
And perhaps your lordship could just for the record describe Dr. Clayton Sewell's occupation at the, yes.
Is a consultant general and forensic psychiatrist. He has, it doesn't say here, but he has been involved in the course in terms of forensic psychiatry, which is the branch of psychiatry which is especially dealing with aspects of matters in court, including criminal matters, and has been, to my knowledge, been involved in that service for over 10 years. So we have that, and that has been something which has been considered by both parties.
Very well, my lord.
I believe you are now anticipating in terms of the victim impact statement.
That is indeed so, my lord. And with your lordship's leave, I would indicate that we would be appreciative if we now have the reading of the victim impact statements
Very well.
into the record. We have two such documents. We have one from Mr. Kishon Henry, and we also have one from Gwendolyn Wright.
Very well. Mr. Registrar, if you can take us through those statements. And just to indicate for the record, the victim impact statements and concerns of the, in this case, when we say a victim impact statement, we are talking about relatives, close relatives of the deceased. These are factors that the court will always take into consideration. This is something that has been put before the court. I had said before that there were considerations of relatives of the deceased, which are in the social inquiry report. This is a more expansive indication of their concerns and how the departure of this family has affected these close family members. Yes, Mr. Registrar. Counsel on both sides, for the record, do we have, especially for the Crown, do we have the freedom to read the name and occupation of these persons, or is it something which is confidential?
Well, I think we would have to read the name, but perhaps
Not the occupation.
or the address or the telephone number. Well, it's a matter of public knowledge anyway. That is so. So the occupation and the name, but nothing else. Thank you.
self-employed. State, I am the mother of 4 children, 3 boys and 1 girl. The oldest child being 33 years of age, and my daughter, Kimisha Wright, who is second, being 31 years old. The other 2 boys are 21, aged 21 and 19 years old. Kimisha was born in Olargo Bay on the 13th day of September 1990. She is affectionately called Trinity, or Reds, by persons within the community and was well loved. Up to the time of her death, she was living at New Road, Cocopies, which was rented by herself and fiancé, who is a member of the Jamaica Defense Force, JDF. She was the mother of 4 kids, 3 girls and 1 boy. The name of the children are Amanda Smith, who is 15 years old, Charlie Smith, who is 11 years old, Rafaela Smith, 5 years old, and Rushane Henry, 23 months old. The latter is for the member of the JDF, whose name is Rushane Henry. The father of the 3 girls are Rafael Smith, who is currently living in the United States of America, USA. Kimisha used to work at a cash pot place in Chappleton, but over the period of time, she left that work and decided to open a little shop for herself, where she would sell little snacks and juice, alcoholic beverage, etc. The shop was located a little distance from her house, which she operated for about 2 years. However, since she got pregnant with the last baby, she decided that she wanted to stay closer to her children at night. Hence, she closed it down and started to do sales from the confines of her home. She was such a progressive and caring young lady, to the point where even though she was operating the shop and sending her children to school, she decided to uplift herself by furthering her education, where she decided to enroll at the Distinction College of Nursing, located in Spanish Town, St. Catherine, where she attends school Monday to Friday, about 9 a.m. until 3 p.m. This was so since the birth of young Sean Henry. Being my only daughter, Kimisha and I had a very good relationship. I could rely on her for anything at all. If I need something in anything, I could call on her, and she would be there. I am currently suffering from knee problems, which from time to time my right knee tends to swell and cause a lot of pain, which hinders me to hardly move. I currently operate a mini-mart shop at Cocopies, and whenever I need assistance to do any lodgement and to buy goods at the wholesale in Macon, once she is not going to school, she will assist without hesitation. She is very reliable. Apart from assisting with my business, she will also be willing and able to assist with any other personal stuff that I will ask her. Whenever it is my birthday or Mother's Day, I know I can rely on her to give me a little present for my birthday, or to cook a nice dinner for me on Mother's Day. On other occasions, I can make me happy. Rushane Barnett, OC Jet, and his brother Jamie, I don't remember They are my nephews. They are my sister Janet's sons. And they live in Wilson Run, Trelawney. About a year ago, Rushane and his brother called me and told me that they wanted to come Clarendon because they want work as nothing was happening for them in Trelawney. So after I got the call, I called my sister Janet to ask her if everything is okay up there, about 5 times, and if she is sure if they do anything up there, and if that is why they want to come to Clarendon. And she said, no, I work them want. I took her words for it and invited them to my home, where I got jobs for both of them. Jamie was working at Lisa Wholesale, located at Guinea Tree, Maypen, and Rushane was working at Bobo Supermarket in Chapelton. During the time whilst working in Chapelton, When I walked into the auditorium and saw the 4 caskets, I had to immediately run out of the auditorium and went to the side, and I cried so hard. After a while, I tried hard and I went inside and viewed the bodies. As I was walking, my knees began to get weak, and a co-worker held me up. 4:05 p.m., I attended the Mapen police station and gave this statement to the police in the presence of Detective Sergeant Nadine Banton and Detective Inspector Philip Dodd. The statement was read over to me, and I signed same in the presence of Detective Sergeant Nadine Banton and Detective Inspector Philip Dodd as true and correct. This statement, consisting of 3 pages, each signed by me, is true to the best of my knowledge and belief, and I make it knowing that if it is tendered in evidence, I shall be liable for prosecution if I have willfully stated anything I believe to be false or do not believe to be true. Signed, K. Henry, 19/8/22. Recorded by me, Detective Sergeant Nadine Banton, a member of the Jamaica Constabulary Force, on Friday, 19th August 2022, about 4:05 p.m. at Mapen Police Station, Clarendon, in the presence of Detective Inspector Philip Dodd, a member of the Jamaica Constabulary Force. It was read over by me to the maker, and we signed in the presence of each other and Detective Inspector Philip Dodd. Signature, date 19/8/2022.
Thank you very much, Mr. Registrar. Yes, Madam King's Counsel.
May it please you, my lord. May I just indicate for the record that this morning I and my team met with Mr. Henry and Miss Wright, and we explained the process and what was to be expected in the sentencing hearing and aspects of law and the stance that the Crown would be obliged to adopt. May I also commend the MID police and my learned colleague, Mrs. Martin Swaby, who I had assigned to work with the police so that this matter could come to the court and facilitate the successful completion of the matter. Because from the time the incident occurred, my lord, about approximately 1 week later, given the consultation between the Office of the DPP and the MID police, we were able to prefer a voluntary bill of indictment straight to the circuit court to have the matter here. And may I also commend my learned friend, Ms. Tamika Harris, attorney at law, for having answered the call of the registrar to take on this assignment. In what is a very difficult and challenging matter for all persons concerned. May I also, as I did indicate to the relatives of the deceased, record our condolences to the family in this very unfortunate matter. And we are indeed sorry for their loss. Now, my lord.
Forgive me, Madam
Yes.
DPP, but I think that
Yes.
in the circumstances, if you could just explain the voluntary bill and why this matter has reached here at this time.
Very well, my
There,
lord.
there are persons who will be saying that there are matters which have occurred, and this is a matter where the statements were taken on the 22nd of June, and the matter is now at this stage on the 22nd of September of the same year. That is unusual, and I think it is necessary if you can indicate some of the how that would have happened in this particular case and what might make this case different from some others.
Well, my lord, first of all, this matter involved the murder of 5 persons in a community, a mother and her 4 very young children. So there was a high public interest, not only in the community, but locally in Jamaica and internationally. We worked with the police who had reached out to us, and it was quite clear that the evidentiary material that had been gathered pointed to an early resolution of the matter. And once we got word, this was on the 22nd of June, that the accused, who had been taken into custody shortly after this incident, that in the presence of his attorney, he had cooperated and confessed to the murders, then it was incumbent on the Office of the DPP, on the DPP, to make a judgment call along with the police and to use the powers under the Constitution to prefer a voluntary bill of indictment to initiate prosecution of this matter straight to the circuit court. Also, it was deemed that the Home Circuit Court would have served the interests of courts better than allowing the matter to stay in Clarendon. Yes. Yes. Okay. I'm just moving the mic a little bit away. Yes. My lord, I constantly try to speak in a soft tone, but so far it has escaped me. It's genetic. Yes, my lord. So in the particular circumstances, in terms of fairness also to the accused, we thought that the interest of justice would have been served better for all concerned to not only move the matter quickly to the Home Circuit Court, which would have offered perhaps a pool of jurors who would have been less affected, we hoped, than jurors in Clarendon, in what really is a very heinous matter, which has energized public revulsion. So it really was the police and the Office of the DPP having been able to gather the evidentiary material in very short order and then using the powers under the Constitution to bring it before the court in the interests of justice. And each case, as your lordship would be aware, has to be assessed on its own particular set of facts. So it was just fortuitous that these set of facts allowed the state actors to move very, very quickly. Now, my lord, we have served sentencing submissions, but I do not propose to go through all of it. But I will highlight salient parts. I would ask your lordship to allow an amendment to paragraph 27 for it to be removed in its entirety. Paragraph 27. Now, my lord, I think it would be good to deal with just an element of the report from the psychiatrist to get that out of the way, because it is quite clear from the report that the assessment of the forensic psychiatrist, who had a lengthy interview with him, and may I indicate, would have been in possession from the registrar of all the documentary material, the statements, the pathology report, the forensic reports, and would have had that available when he interviewed Mr. Barnett. And what he found, basically, was that using a psychopathy checklist and a particular screening, his assessment of Mr. Barnett at page 8 of the report indicated the presence of superficial charm, glibness. This refers to a tendency to be smooth, engaging, charming, slick, and speak with fluency and ease. Deceitfulness, the quality of being disingenuous and lacking openness. 3, lacking remorse, an absence of a sense of deep regret and guilt for some misdeed. 4, lacking empathy, a failure to identify with and understand another individual's situation, feelings, and motives. 5, doesn't accept responsibility, failure to accept responsibility for one's own actions. 6, irresponsibility, a pattern of being unreliable and untrustworthy behavior. 7, adult antisocial behavior, behavior that violates accepted morals of a society that occur after age 18. He also indicated at page 8, Millard, that there is also the possible presence of 1, impulsivity, a tendency to act on impulse rather than thought, and 2, poor behavioral controls, a tendency to exhibit socially inappropriate behavior despite recognition of its deviance. And in a summary of conclusions at page 3, the forensic psychiatrist found that Rushane Barnett admits to killing the 5 persons, but claims that voices in his head forced him to do so. 2, he has no prior reported history of psychopathology, but claims he has been hearing voices since age 18 years. 3, based on Rushane Barnett's report and history, he was not influenced by an abnormality of the mind at the time of the alleged offense. 4, he understands the nature of the offense, but describes the incident as a result of Obia reaching him and forcing him to act. 5, he has no major mental illness, but displayed antisocial personality traits. 6, he currently has no suicidal or homicidal ideas. 7, Rushane Barnett is fit to plead, and hence a trial can proceed. And this report is dated July 27, 2022. Millard, let me deal frontally with the issue of the death penalty notice. Your Lordship may recall that when the matter, the voluntary bill of indictment, was preferred, and the matter made its first appearance before Your Lordship at the Home Circuit Court, Mrs. Martin Swaby, my Senior Deputy Director, on my instructions, also issued the death penalty notice. And this was in line with the dictum in the case of Jeffrey Perry, which I believe has been served on the court. Jeffrey Perry and the Queen, judgment delivered. This is Supreme Court Criminal Appeal number 10 of 2009, judgment delivered on the 30th of March 2012. Your Lordship may recall that that was a case where, referred to as the Killen-Colley murders in St. Mary, where Mr. Perry killed his 3 young cousins, members of his family, stabbed them all to death during their sleep. In that matter, the psychiatrist found that he had OCD, I think obsessive compulsive disorder. And he was tried, and the Crown had served the death notice very late in the day, and he was, at the end of the trial, sentenced, given the death penalty. On appeal, the court, well, I appeared in the matter, and I conceded that it was late in the day, so that he did not have the benefit at the beginning of the trial or when the indictment was preferred to know exactly that this option would have been pursued by the Crown, and the court then vacated that particular sentence and substituted a sentence of life imprisonment on each count and 45 years before parole can be had. In this matter, the accused has pleaded guilty to killing 5 persons. The Crown did properly serve the death notice, but in light of the fact, and we have explained this to the relatives of the victims, in light of the fact that at the first relevant date, Mr. Barnett has pleaded guilty to all 5 counts of murder on the indictment. As a matter of law, the Crown would then be obliged to remove the option of pursuing the death penalty as an option in sentencing before this court. And this is a matter of law, because everyone who pleads guilty is entitled to some amount of credit for pleading guilty. In a case where the death penalty is on the table, the law would prescribe or oblige us to recognize that the credit would see the issue of the death penalty as an option being taken off the table. Therefore, in terms of the question of sentencing, life imprisonment would clearly be the part of the sentence, and what would really occupy your Lordship's mind would be the number of years that the accused would have to serve before being granted parole. Thank you very much for the correction. Would be eligible for parole. Yes, my lord. Now, your Lordship would be very au fait with the authorities on sentencing, and coming from the well-known locus classicus, The Queen Against Sargent, 1975-60 Criminal Appeal Report, page 74 at page 77, it was enunciated that the principles of sentencing that would occupy the sentencing judge revolve around restitution, deterrence, rehabilitation, and prevention. And there are two aspects to deterrence. You have the deterrence, according to Mr. Justice Rowe, of the offender and the deterrence of likely offenders. I'm at paragraph 9 now, my lord. Having considered the principles of sentencing, the Office of the DPP considers the proposed methodology to be employed in arriving at the appropriate sentence as that encapsulated in the case of Daniel Rulston and the Queen, that's Roulston, 2018 JMCA Crim 20 at paragraph 17. And here, the approach and methodology in the sentencing process that is desirable in terms of being employed is A, identifying the sentencing range, B, identifying the starting point of the sentence, C, considering the relevant aggravating factors, D, considering the relevant mitigating factors, E, considering any reduction of the guilty plea, and F, discounting the time spent in custody. Your Lordship would be au fait with the locus classicus Misha Clement and the Queen, that is 2016 JMCA 26, which deals with the whole issue of the approach to be taken in sentencing when one is looking at the eligibility or non-eligibility for parole. And in a very seminal judgment, Mr. Justice, the President of the Court of Appeals then, Mr. Justice Morrison, outlined the particular approach to be taken. He stated that in seeking to arrive at the appropriate starting point, it is relevant to bear in mind the well-known and generally accepted principle of sentencing that the maximum sentence of imprisonment provided by statute for a particular offense should be reserved for the worst examples of that offense likely to be encountered in practice. May I pause here to say, my lord, that certainly as I searched my experience, and we also picked the brains of several other senior members of staff, including my learned colleague, and I get the pleasure of saying this for the first time, Mr. Jeremy Taylor, KC. And given our research, we could not find any case law from the Court of Appeal, certainly in Jamaica, that had dealt with the murder within the same narrative of 5 individuals. There is one case that I prosecuted, your Lordship may be aware of it, but it's still at first instance, it's on appeal, but it has not yet been heard. Michael McLean, who was convicted of 6 counts of murder, which involved 2 adults and 4 children. I prosecuted that case. But it is yet to be heard by the Court of Appeal, and in fact, when I inquired, the date for hearing is next year, June 2023. So it would seem, my lord, that your Lordship, in terms of sentencing this particular matter, will certainly be rubbing shoulders with the judge who dealt with that matter as pioneers, given the particular circumstances of this case. And even so, this would be a first, even compared to McLean, because in McLean, the murders took place at 3 defined locations, one at the beach, one in the hinterlands of St. Thomas, and one in the hinterlands of St. Mary. In the case at bar, this incident took place in the same locus, in the same home, at almost the same time. And it was part and parcel of one continuous activity by Mr. Barrett. So dare I say, my lord, your lordship will indeed be a pioneer in terms of the peculiar aspects of this case. So we have found no case, certainly in the Court of Appeal, that would necessarily offer guidance in respect of 5 persons being victims at the same time of murder. However, we did look at several cases which we have listed in paragraph 14, because we take the view that even in the absence of seeing any definite case law dealing with 5, that on any platform, in any language, this would have to be the worst example of an offense of murder that we have seen in this jurisdiction. And therefore, we would be inviting the court to go above what has been recorded so far, given our research in the Court of Appeal cases, of the highest sentence, which is, it would seem to be 45. The last time I saw 50, it was in the Lyndon Levy et al. Case, which was a rape case, and the 50 years. That was a case where 2 young teenagers had been raped over the space of 2 days by about 9 men. 7 or 8 of them, and it was videotaped. 7 or 8 of the men, I prosecuted that case too, were convicted, and the ringleader in the matter, who was doing the videotaping, was given 50 years by the learned sentencing judge, but in the Court of Appeal, it was reduced to below, I think it might have been about 30, 35. However, we will be inviting your lordship to view this particular case against Rushane Barrett as the worst example referred to by Mr. Justice Morrison in Misha Clement. Therefore, we would be inviting your lordship to go, well, I was going to say go outside the sentencing range, but we don't have the sentencing range for this type of offense, which is why I did say that your lordship is going to be a pioneer. But we'd be inviting your lordship to go outside of what we have so far as a sentencing range, which goes up to 3 persons being murdered. And your lordship would be at liberty, as indicated by the authorities, to give the particular reasons as to why the interests of justice could only be met by going outside the sentencing range. Now, in paragraph 14, the normal range of sentencing for the offense of murder is between a fixed term of 15 years to life imprisonment. Table 1 provides cases where multiple persons were killed during a given incident and indicates the range of sentences that have been handed down in the Court of Appeal in Jamaica. We have Garland Marriott, a 2012 case, JMCA Crim 9. There, the appellant was convicted of 2 counts of murder, and sentence imposed was life imprisonment 25 years before becoming eligible for parole on both counts to run concurrently. Ian Gordon and the Queen, 2012, JMCA, Crim 11. The appellant was convicted of 2 counts of murder. Life imprisonment was imposed 30 years before eligibility for parole in respect of each count to run concurrently. Alton Heath, Desmond McKenzie, Marlon Duncan, and Chadwick Gordon. I'm sorry. Alton, it should be Heath. Alton Heath, Desmond Kennedy. I made an error there. A terrible error. That should be Alton Heath, Desmond Kennedy, Marlon Duncan, and Chadwick Gordon versus the Queen, 2012, JMCA, Crim 61. The accused men were convicted of 2 counts of murder, the furtherance of abduction or rape, or indecent assault. And there we had a sentence of life imprisonment being imposed 35 years before eligibility for parole. And for the alleged ringleader, he was resentenced sometime after, and he received 27 years before eligibility for parole. We have David Russell versus the Queen, 2013, JMCA, Crim 42. The appellant was convicted of 2 counts of murder. On count 1, he received 30 years imprisonment at hard labor. On count 2, life imprisonment and 40 years before eligibility for parole. The Queen against Fabian Skirvin, 2021, JMSC, Crim 7. The defendant pleaded guilty to 2 counts of murder, and he received a sentence of life imprisonment, 37 years and 4 months before eligibility for parole on both counts, and sentences to run concurrently. The Queen against Wade Blackwood, and your sister, Mrs. Justice Shelley Williams, wrote a first instance judgment. It has not yet gone to the Court of Appeal. 2021, JMSC, Crim 1. Oh, and I believe that Skirvin 2 is a first instance judgment. The defendant pleaded guilty to 2 counts of murder. And here the accused was given life imprisonment, 35 years and 4 months before eligibility for parole on both counts. Sentences to run concurrently. And of course, we have Jeffrey Perry, which I've already gone into.
But for those 2 matters, though, Skirvin and Blackwood, you actually would have to look to exactly what the court's calculation was, because the 37 years and 4 months and the 35 years and 4 months means that the time spent in custody before trial was already deducted.
That is so, my lord.
In this particular case, the time
it's only about 3 months.
Yes, it's extremely short.
That is so, my lord. And in fact, the learned judge, certainly in Blackwood, in the judgment, she went through a very detailed exercise. Now, my lord, we now go into the aggravating features, but before that, the Crown would wish to commend to your lordship in respect of our assessment, having looked at the authorities, having looked at the circumstances of this particular case, that we would submit that the most suitable starting point for each count on this indictment would, of course, be life imprisonment at hard labor with an eligibility for parole not before serving 55 years. I would just repeat. It is the Crown's submission, which we would commend to the court, that the starting point in this matter should be that eligibility for parole, life imprisonment eligibility for parole would be 55 years. That would be the starting point. We believe and we recognize that it may appear to be high, but we believe that the circumstances of this case oblige us to start at that point. The aggravating features which we would commend to your lordship, we have listed at paragraph 17. 1, the ages of the victims. It involved the brutal killing of Keshawn Henry, 23 months old, Kimanda Smith, 15 years old, Shara Lee Smith, 11 years old, Rafaela Smith, 5 years old, Kemisha Wright, 31 years old. And the incident, this brutal killing, took place in their home. So we juxtapose the fact that you had these young children and their mother, young mother, who were they weren't asleep. They were killed within the presence and hearing and sight of each other. And they were killed within the sanctity of their home between the hours of 12 midnight and 1 a.m. A time that any householder, let alone children, would be at their most vulnerable. 2, the nature of the injuries, Millet. Kemisha Wright suffered 48 incised wounds, all in the region of her neck, chest, and limbs. Keshawn Henry received 11 incised wounds, inclusive of an incised wound to the neck, which has been described as a cutthroat injury. Kimanda, and that is Keshawn Henry, the 23-month-old toddler. Kimanda Smith, 15 years old, suffered 9 incised wounds and 4 stab wounds. Shara Lee Smith, 11 years old, suffered 22 incised wounds and 2 scratches. Rafaela Smith, 5 years old, suffered 5 incised wounds and a gaping wound to the upper anterior neck, cutthroat injury. 3, the deceased persons were all family members of the accused man. An accused man who, when one looks at the social inquiry report, when one looks at what the relatives of the victim say, when one looks at what the accused himself says, he was the constant beneficiary of the generosity of his cousin, Miss Kemisha Wright. At all material times, he was the beneficiary. When one looks at what the father of Keshawn Henry, Miss Kemisha Wright's partner, says, at all times he was given, he had courtesies extended to him from the family. You know, Millard, your lordship is not a jury, but had there been a jury, the Jamaican expression, sorry for Marga dog, they turn around and bite you, comes to mind. So, that again would be an aggravating factor. 4, the accused man was a person in authority and an occasional caregiver for these children. He was a person in authority and an occasional caregiver. 5, the accused not only threw away the shorts, but also the bloody knife that he had used to inflict the injuries. shortly after the incident, and then took himself away from the scene to hide. 6, the accused, as I indicated earlier, based on the forensic psychiatric report, was not laboring under a psychiatric illness. It is quite clear that the accused knew exactly what he was doing. 7, the account which has been given by the accused as to the manner in which the deceased persons met their demise suggests that there was a clear and calculating intention to kill Miss Kamisha Wright, and that he inflicted wounds on Miss Wright in clear view of her 4 children. In fact, I believe that when he first attacked her, she had one of the children in her hand. A further aggravating feature is the fact that the children would have thought, first of all, they would have been totally traumatized, but nonetheless sought in their own little way to protect or to defend their mother. And I believe it is in the question and answer that he said, yes, he was asked. He was asked in question 73, were you attacked by any of the kids? Answer, yes, the 2 big ones. Question 74, what you mean by attack? Answer, as when me tell you, then grab something, stuff off of the dresser, like baby lotion, baby oil, money pan, and scissors, said way. And then the question, so you can recall if you cut any of them throat? Answer, to how the thing happened, me not sure. Did anybody assist you? Question 76, no. So, my lord, we have a picture of the absolute trauma that those children would have been going through, seeing their mother being attacked by their cousin 48 times in terms of being stabbed. And they tried to assist their mother as young as they were. Whereupon the accused turned on them. And of course, we have to remember that according to the accused, the attack on the mother came about because he felt disrespected. And we go back to what the doctor said, because it's important. Superficial charm, deceitfulness, lacking remorse, lacking empathy, doesn't accept responsibility, irresponsibility, adult antisocial behavior, impulsivity, poor behavioral controls, a tendency to exhibit socially inappropriate behavior despite recognition of its deviance. So he was aware and master of his thought. He knew exactly what he was doing. But he clearly had a sense of entitlement, that he was entitled to execute this mother and her 4 children because he had been disrespected. So, my lord, I was going back to my submissions. That is so. I got your lordship's telepathic thought. And in paragraph 8, at number 8, the final aggravating factor, the account which has been given by the accused as to the manner in which deceased persons met their demise suggests that there was a clear intention, as we have stated, and I would put calculating. The further aggravating feature is the fact that the children would have sought to protect and or defend their mother, which resulted in the accused inflicting wounds on all children with the intention to also kill them. This series of events occurred as the children were in full view of each other at their home, so that enhanced and exacerbated the trauma to these children. These factors give rise to a set of serious aggravating factors. These factors can be deduced from the account given by the accused in his caution statement and in his question and answer interview. In his account, he stated, and we quote, in summary, "It looked like she had come out of the bed now, and it seemed like she see me a prayer. So she make after something upon the dresser. Me no see her what, but me a pray in my heavens, say it either a knife or scissors. Me rush her now, cause me did have a knife. Then me start stab her up. She drop the pitney them, get up here now chin, and promise wish pan the dresser, take up 2 things in them hand, and start fling it after me. Me never really see what that good, so me start grab after them, you know, and start stab them up. To the big one, draw for your scissors. When me see that now, she rush in her room, and she drop her, me start stab her up. So everybody dead now. So me change off, throw the shorts and knife over the right side, where the ackee tree there, over the bush, and bounce." And the 8th, as outlined in the facts of this case, on the 28th day of July, 2022, the accused had told some persons on the night of the incident that he was going to leave country today because he might go kill some people. This also, my lord, would suggest that though he felt disrespected, that his actions between 12 midnight and 1 o'clock on that fateful morning was premeditated and not spontaneous. This, in terms of what he told, this evidence of premeditation, we submit, would also be an aggravating factor. Mitigating factors, well, we searched for the mitigating factors, which your lordship would have to consider. 1, that the accused entered a plea of guilt on all 5 counts of the indictment on the first relevant date during the proceedings for the purposes of the Criminal Justice Administration Act 2015. And 2, it would appear that he has expressed remorse by doing so. It is our submission, however, that the accused should not benefit from the 33 or up to 33.33% discount based on this early plea of guilt at the first relevant date. I'm at paragraph 19. Section 42E1 to 2A of the Criminal Justice Administration Amendment Act addresses the treatment of a guilty plea being entered for the offense of murder. It states that where the accused pleads guilty, the court may reduce the sentence by up to 33.33% of the sentence which the court would have imposed had the accused been convicted after a trial been concluded. However, Section 42E4 states that if the court is minded to reduce... I'm sorry. Should I go back to 20? However, yes, my lord, thank you. Section 42E4 states that if the court is minded to reduce the sentence on the basis of a guilty plea for the offense of murder, the court shall have regard to the provisions of Section 42H of the Act. The effect of Section 42E1 to 2A and 42E4 is that any consideration of a reduction must be subject to the principles in Section 42H. Based on Section 42E 2A of the Act, since the defendant indicated to the court on the first relevant date that he wishes to plead guilty for the offense of 5 counts of murder, the court may, under the Act, reduce the sentence by up to 33 1/3. However, Section 42H indicates that in determining whether the sentence should be discounted on the basis of an early plea of guilt, the court should have regard to A, whether the reduction of the sentence of the defendant would be so disproportionate to the seriousness of the offense or so inappropriate in the case of the defendant that it would shock the public conscience. B, the circumstances of the offense, including its impact on the victims. C, any factors that are relevant to the defendant. And D, the circumstances surrounding the plea. The Crown is of the view that in the present case, if your lordship decided to even reduce the sentence by even up to 1%, it would shock the public conscience, given the circumstances of the case. Also, the circumstances of the offense, which I earlier outlined, and the impact on the relatives of the victims and the community, because your lordship heard from the statement of Miss Gwendolyn Wright, the mother of Kamisha and the grandmother of the children, and from Mr. Henry, the father and the partner of Kamisha and the father of the youngest child, the kind of impact it has had on the family, on them, on the community of Cocoa Peace, and that this impact will be far-reaching, possibly to the end of their time on earth. So the circumstances of the offense, the trauma that all 5 persons, the 4 children, and their mother, the fact that it was done in the sanctity of their home, the fact that it was premeditated, cold and callous, the fact that he took himself away to hide the implements, hide the bloody shorts, and to hide. All those circumstances would render it inappropriate for any discount, any of that 33 1/3% to be given to this accused in the sentencing. So we would ask your lordship not, because it's discretionary, not to reduce the sentence at all by anything in terms of the 33 1/3%. Of course, the Crown is cognizant that the time in custody, according to law, would have to be taken into account. And the time period that would need to be deducted would be about 3 months. So in the circumstances, the Crown submits that with a starting point of 55 years before becoming eligible for parole, 8 years, that is 1 year for each of the 8 aggravating factors, should be added to the 55. That would make it 64. That's no, 50, 55 plus 8 would be 63. Thank you. No, 63. 2 years, that is one for each mitigating factor, ought to be deducted. That would take it to 60, 61, and then we would have to deduct the 3 months that he has spent in custody. So that would take it to 60 years and 9 months in respect of each count. So it is our submission that the accused should be sentenced on each count to life imprisonment, and he should not be eligible for parole before serving 60 years and 9 months. Yes. Also, we commend the Roderick Fisher case, that is versus the Queen 2008, to your lordship. But before I close, and I'm about to close, my lord, your lordship will note that in the Jeffrey Perry matter, that is the Killancolly murder matter, looking at the last page, paragraph 9, the court took the view that in their deliberations, counsel for the defense was saying that the pre-parole period should be 35 years. But the court took the view, and I quote, that in our deliberations, a period of upwards of 50 years was considered, but was discounted upon such weight as we felt the mitigating features deserved. And we have come to the view that an appropriate pre-parole period is 45 years. In the Jeffrey Perry matter, my lord, at the time of the Court of Appeal hearing, he had been in custody for some 7 years. So the 7 years was part of the discount that he received. But as far as the court was concerned, for the murder of 3 persons, 3 children, they did not have a problem of going upwards of 50 years. In the case at bar, we are dealing with the murder of 4 children and an adult, all done at the same time. So I would commend, although this reasoning was delivered in 2012, prior to the Misha Clement case, I would still submit that it would be persuasive to your lordship in terms of, if it is, and of course I take the point that this was a full trial, and in this case, it's a plea of guilty, but the fact that they were willing to consider upwards of 50 years in respect of the circumstances of this case would be something that I would ask your lordship not to ignore.
Just to indicate that I don't think the court's position is that Misha Clement changed the law.
That is so, it clarified it.
Yes, what Misha Clement merely did was to clarify and set out and perhaps consolidate the principles
that had been there,
which had existed before.
Very well, my lord. So I am closing now, my lord.
Yes, you've used your 30 minutes very well.
Yes. I'm closing down, my lord. But we would say that in the case at bar, we are reminded that similar to Roderick Fisher, in that case the death penalty was considered but was withdrawn or retracted. And it's a moot point, because we served the death notice. Some persons would think that, do we withdraw it now? Or it's a question that it was there, but because the law obliges the whole issue of that option to be taken off the limit, it's really arose by any other name, being still as sweet. The Crown adopts the utterances of Judge of Appeal, Mrs. Justice Norma McIntosh, in the Jeffrey Perry matter, where it was indicated that when one weighs the aggravating features against the mitigating features, and I quote, "The sheer horror, according to the account given by it would be the accused, the slaughter of the innocents, the slaughter of the innocent, who could have posed no threat to him, as they were asleep in the Jeffrey Perry matter. In this case, these were even younger children, apart from the 15-year-old. And the only thing that, according to him, they sought to arm themselves with was a bottle of baby oil or baby lotion to throw at him, whilst he, as if he was some sort of samurai armed with a knife, was intent on carving up all these innocent people. In this case, all of the victims were awake and in the present sight and hearing of each other, observing what was happening. I also would commend the fact that one has to balance, as a sentencing judge, the public revulsion, and I repeat, the public revulsion, my lord, at the diabolical actions and the reliance of the public on the credibility of the justice system by members of the said public to mete out adequate punishment would make it incumbent on us. It obliges the Crown, in all the circumstances, to have made the recommendation of life imprisonment on each count, parole, eligibility for parole not before serving 60 years and 9 months. We submit, finally, that given the circumstances of this case, that the interests of justice would be met by the accused, Rushane Barnett, being so ordered by this honorable court to serve this term of life imprisonment at hard labor with eligibility for parole after serving, or not before serving, 60 years and 9 months. On each of the 5 counts, with sentences to run concurrently. For it to go any lower, and this is just my humble view, it perhaps may shock the public conscience. May it please you, my lord.
Ms. Harris, we are at the normal break time. If you wish to proceed, I don't think I will have any difficulty. The court report. I see. All right. You want? Yeah, I know. Do you want to? We can take a 15 minutes, or we can deal with it. All right, that's fine. Okay. Yes, we're going to take a short break. The court reporters are those are the persons who have to be concentrating on following everything. If you are amenable, Ms. Harris, since you are next, we'll just break for 15 minutes and continue after that, or do you need a full luncheon break?
My lord, I was hoping to go now instead of waiting under 15 minutes. Yeah, but I understand the court reporter's needs, and in the circumstances, 15 minutes.
Very well. Okay. Very well. We'll rise for 15 minutes. Yes?
My lord, before your lordship rises, could we just ask for the court's leave for paragraph 27 to be deleted?
Yes, I think you had indicated at the beginning.
Thank you.
Right. Court rises for 15 minutes.
What I did, I jumped it around. Because, no, had to. Because the thing is, everybody was he crazy? So I had to deal with that first to show what current psychiatrist has to say. You understand what I mean, Jeremy? No, but everything is right.
But you would have had to. You would have had to.
No, no. That's why we had to go in detail. Because they don't understand. You are obliged to take it off the table. You can't have him plead guilty and you can't see. I can you remember you can't see.
You told like.
Take some of the cube.
No, Mr. Salter was crying.
No, I wouldn't want to see it. I can't manage it. No. You saw it? No, I can't manage it.
I'm not interested in those things.
No.
Not even in the normal
Right.
run-of-the-mill murder.
Because I never looked at even the little girl that in the 9-year-old. I never looked at it. When
Not
else?
interested. You serious? You mean that is things? Sean, my juniors look at the CDs.
Yes, my juniors too. I don't look at it. And then they filter it and tell me about it.
July 2022. Do you wish to say anything before the sentencing of this court is passed upon you, sir?
Yes, Ms. Harris.
If it so pleases you, my lord, my learned friend and senior Casey highlighted all the aggravating factors, and we cannot deny them. And in fact, Mr. Rushane Barnett has not denied them. And it's for that reason I start here, my lord, because he has not only pleaded guilty at the very first instance, the very first opportunity, but what he did, he made contact with a warden to turn in himself. And after the dialogue with that person, he said, "Me go stay in the crib till the police them come." My friend painted the picture as if he was someone hiding and running. But what he did certainly contradicts that. Me I go stay in my crib till the police them come. And after staying in his crib till the police them come, he also gave a caution statement. And consistent with not hiding away from what he did, and consistent with showing his remorse, he came to court, and without counsel, he indicated an intention to plead guilty. And with counsel, he did just that. My lord, it is for that reason I am asking the court to offer him the discount that my friend so eloquently tried to say to you, you ought not to give him. It is the court's discretion, we are aware, but in these circumstances, my lord, the offender did not waste the court's time. The machinery of the court has not been put in gear. There is no need for a trial, no need for the family to give evidence, to relive the ordeal. There is no need for forensic experts to leave the lab to come and give evidence. There is no need for other court resources to be utilized. He has saved the court's time and resources. My lord, there is much emphasis on the need for accused persons to plead guilty. And if we ignore the fact that he has pleaded guilty, we are saying to others, what is the point? We are saying to others, why should I? My friend is putting to you cases, Michael McLean, Jeffrey Perry, and suggesting to you starting points. But in those cases, those persons had a full-length trial, not just trial. They also went to the Court of Appeal. I am asking you, my lord, to take into consideration the fact that he is throwing himself upon the mercy of the court. He has pleaded guilty at the very first opportunity.
Ms. Harris, not to take anything from the Crown or to argue their case, but as a legal point, I think what the Crown is saying is that the allowance which has been made for his guilty plea is the fact that the death sentence is no longer on the table, and that any further consideration, the court should use its discretion to waive it in the circumstances. So
I hear my friend and I understand what the court is saying, but I am saying the court should go further, because not only did he plead guilty, but he also gave a caution statement, and he also stayed in his crib until the police arrived.
Very well, I understand you.
My friend started at 55 years, my lord, and she said she started that high because of the aggravating factors. But what she did after starting that high, because of the aggravating factors, was also added more years because of the very same aggravating factors. I'm asking the court to consider the aggravating factors twice by starting so high. I'm asking the court to bear in mind the youth of the offender, the fact that he has pleaded guilty and shown remorse, but also bearing in mind what was said or uncovered in the social inquiry report. He said, my lord, at page 2, subject said he was sorry for what happened. He furthered that if he had the opportunity to speak with the victim's mother, who is his aunt, he would tell her he heard voices in his head and could not resist doing what he did. Offender expressed hope of leniency in sentencing by way of a reduced term of imprisonment. My lord, his brother indicated that his brother started working as a landscaper at the University of the West Indies, which lasted for a short time. He said that he was shocked and devastated because, my lord, there was no prior display of behavior which would have suggested him being capable of such. My lord, it seems to me, based on a reading of the social inquiry report, that this is very unusual behavior for Mr. Barnett. And this is consistent with the fact that he has no previous conviction. And that is another factor, my lord, I would ask you to take into consideration when sentencing the offender. His parents, my lord, suggest that he was well behaved whilst growing up and that they were never compelled to use harsh punishment on him. Despite facing financial hardships at times and depending on social welfare programs to assist with supporting the children, Rushane stood his ground and never brought the family's name into disrepute. My lord, Miss Gwendolyn McKnight, said that she shared a good relationship and that the offender also shared a good relationship with Miss Wright, and their children. He is described by persons in Tavern Drive, my Lord, as peaceful, quiet person who was never a problem to the community and got along well with everyone. My Lord, this begs the question, why are we here? If Mr. Barnett is such a peaceful person, what really could have happened? And I asked that question, and I know there's no hope of anyone answering. But sentencing him to 1 million years is not going to solve the underlying problems that we have in the society. The members of the society is naturally shocked, and this is brutal, but the court is not acting on the whimsy and the fancy of the public. The court must do a balancing exercise and take into consideration all the mitigating and all the aggravating factors. The court cannot say that it is not applying a discount merely because of what society may think. The court must be cognizant at all times of its responsibility as judge. Social media cannot dictate to the court how the court ought to function. My Lord, I am fully cognizant of the report from the psychiatrist, but I would ask the court to observe that Mr. Barnett was seen only once by the psychiatrist. No interview was done with his other family members to get a full history. And I do believe that the ideal situation would be, my Lord, for at least more than one visit, and even for more than one expert to form an opinion so that the court could readily accept. I'm asking the court to bear in mind that even though the report speaks to the lack of remorse, that the social inquiry report, based on what he said, that he was sorry for what he did, and based on the fact that he pleaded guilty, that the court must consider that Mr. Barnett showed remorse, or is showing by pleading guilty to this court, that he is remorseful. And as a matter of fact, my Lord, I do believe that the case law suggests...
One moment, madam. And please forgive me. I'm not being facetious.
You're not, my Lord?
Not in this circumstance, madam. But how do you define remorse? I can say I'm sorry. I'm not suggesting that this is the accused position. I can say I'm sorry, but I do it out of politeness. And just because it looks particular way, and I'm not really sorry.
Well, I can ask the same question. How would the psychiatrist see a lack of remorse?
I hear you, ma'am.
Very well, my Lord. Well, he needs to tell us. He's not here to tell us, my Lord. I hear my friends muttering that he's trained, but it will be on him to tell us what is the reason or on what basis he came to that conclusion, my Lord, bearing in mind that the accused actively said that he is remorseful and the accused man has pleaded guilty. And I do believe that the case law suggests that a plea of guilt in itself is a sign of remorse. My Lord, I did tell you that I will be short, and I will be short. I'm asking the court to bear in mind that Mr. Barnett had no previous conviction, that at all times he was gainfully employed and or actively seeked or sought employment, that he cooperated fully with the police. I'm asking the court to bear in mind the time he spent in custody, and again to consider, my Lord, that he is indeed remorseful. If it so pleases you, my Lord, I'm asking the court to reject my friend's submission in relation to a discount. Your Lordship might not necessarily go to 33.5%. The court does have a discretion, as was enunciated, my Lord, in the case of Regina versus Wade Blackwood. And in that case, my Lord, the court took into consideration all of the aggravating factors and reduced the sentence by 5%. The court was recognized that it was the court's discretion, but bearing in mind, my Lord, that the person, Mr. Blackwood, pleaded guilty, the court appropriately granted a 5% discount. I'm asking your Lordship to bear that in mind. The court also looked at several cases, the case of the Queen versus Hastings. Do we say the King, even though the case was back then with the Queen? It was the Queen, right, so it's the Queen. The Queen versus Landy and the Queen versus Davis. And my Lord, at paragraph 16, page 7, in some cases, the discount on sentence may be reduced or even denied altogether owing to the gravity of the offense or the strength of the case against the offender. Examples include cases where there's an overwhelming evidence against the offender or where he has been caught red-handed. I'm asking your Lordship to bear in mind that Mr. Barnett pleaded guilty before he even had the opportunity to examine the strength of the case against him. That he waited, my Lord, on the police to come and get him. When the police got him, he gave them a caution statement and admitted to the acts. So in light of that, my Lord, I am asking the court to consider granting him a discounting sentence, and I would suggest 10%, my Lord.
But, Madam, have you indicated what you think the starting point is? You're accepting the Crown's starting point?
My Lord, I think an appropriate starting point based on the case in Jeffrey Pearl would be 50 years.
And 10% from that would be 45. But 45 years. 10% of 50 is 5.
Yes, my Lord.
There.
In the circumstances, my Lord, I do believe 45 years before parole would be an appropriate sentence, if it so pleases you.
Very well.
Very well. The court has to consider all the factors here and to set out its reasoning in a format that would be clear and hopefully concise. I am proposing that the sentencing decision of the court would be done on the three weeks from now would give me the 20th of October. On Thursday the 20th, is that a convenient date? 20th of October for decision on sentencing. At 2 p.m. I'm suggesting. It's convenient to the Crown. Very well. Ms. Harris, that's convenient also?
Yes, my lord.
Very well. All right. Stand, Mr. Barnett. Mr. Barnett, what has happened so far is that this has been a sentencing hearing, which means that we've heard from the various parties. I've heard submission from the Crown and from the defense in relation to your sentence. The court will take some time to consider the submissions which have been made and the information which has been passed out, and will indicate to you what your sentence is, and we'll do that on the 20th of October at 2 p.m. in the afternoon. So your matter is adjourned to the 20th of October at 2 p.m., and you'll be remanded in custody until then. Thank you very much, Mr. Barnett. All right, let him have a seat there for the time being. All right, thank you very much. Let me say to all counsel involved, and I had already indicated to the probation officers and other persons who helped with reports. I think that we've managed to deal with this matter as best we could in the circumstances. I would also like to say, Madam DPP, in relation to the officers who investigated the matter, having seen the documents that they have provided and how they acted, I know that everybody would have been, as you have indicated, shocked by the circumstances. And there have been situations where we generally, and maybe even this judge, has indicated that there could be greater alacrity in terms of the police officers operating. In this situation, they did, and they seem to have done so efficiently. So in the same way we indicate when there is this absence, I think that we need to pass this on in these circumstances. And the court does that in this particular case. Very well. Adjourn for me, please.
Stand, please.